Now, some general rules on rights and remedies. There are some new rights and remedies available to secured parties under the new regime, but they are subject to certain qualifications. Probably most importantly for present purposes is they don't apply during a receivership. If the debtor or grantor is in receivership under the Corporations Act, Part 5.2, the enforcement provisions don't apply. That's interesting. Is that going to produce a change of behaviour? Are secured parties going to appoint a mortgagee in possession and go in as a mortgagee in possession in order to get the benefit of the new regime enforcement rules? Or are they going to wait until the end of the receivership and then use these new provisions? If they do that, there'll be nothing left. We know why that is. But I won't go into that because some of my best friends are insolvency practitioners. So they don't apply during a receivership. It's possible for secured parties to contract out of these enforcement provisions. And they will contract out of some of the enforcement provisions. You can't contract out of all of them, but you can contract out of some of them. And in this book we have listed the ones you can contract out of, and we've suggested a clause in which the drafter can use to contract out. Now, I wouldn't just contract out of everything on site. I'd think about it. I'd actually get some dialogue going with your client about what ones they can use and what ones are problems for them, and make a conscious commercial decision and legal decision about what you're going to contract out of. But there's some suggestions in there about ones that you might want to retain and not contract out of. The enforcement provisions do not apply to deemed security interests. They only apply to real security interests. So they don't apply to those 4 deemed security interests like reservation of title clauses, chattel paper and so on. They don't apply to PPS leases. They don't apply to commercial consignments. So they don't apply to those situations. They don't apply to security interests that are conferred for private, domestic or household purposes. So they don't apply in the consumer categories. So there are some exclusions from the scope of these enforcement provisions. The enforcement provisions, though, are cumulative. You can apply all or any of them if they're available. Thank you. Let's look at these new enforcement provisions and what they offer secured parties. These are new rights and remedies on top of what they already have under the existing law, and you then have the option of registering. There'll be... Yes,
sorry,
yes, of course.
Unregistered security interests then not continue to exist under general law?
No, they'll continue to exist and have the current problems they have under general law. For example, no, for that 2-year period. For example, if they're not registered, they'll be void as against an administrator or liquidator under Section 266 of the Corporations Act in that 2-year period. But after the 2-year period has elapsed, they'll be void under PPS A. Okay, so it's a bit complicated. The transition provisions are highly complex, and they make a mockery of this allegation that it's clear and precise drafting. I don't know if you get the Weekend Australian. Have you ever read the Weekend Australian magazine? The column Mystic Medusa, the horoscopes. Does anyone ever understand those horoscopes? The person who does those horoscopes, I'm sure, did the drafting of the transition provisions. It's in the same Delphic style. I understand it's the current Commonwealth style. Well, it's a long way from plain English, I assure you. Changes in terminology. We won't be using terms like fixed and floating charge in a few years. We'll call the mortgage debenture a general securities agreement. And the terms fixed and floating charge will fall into disuse because they're misleading. The new charge that will be recognised under the new regime is a registered fixed charge, virtually from day one. There's no deferment of attachment unless you expressly agree to do that. And you can't do that just by calling it a floating charge. So the terminology fixed and floating charge will fall into disuse. Thank you. Who may appoint a receiver and manager under the new regime? Well, it will be the first perfected secured party, the party with the highest priority. I'm not saying other secured parties couldn't appoint receivers, but they would have to defer to the first ranking secured party's receiver. They'd have to take a back seat, in effect. And you become the first perfected secured party in one of 3 ways. Either by registration of a financing statement, that's just a 1-page statement that can be lodged electronically. Very simple. Only 9 things are included in that statement. Have a look at section 191 to get an idea of what's included. And those 9 things will be amplified by the regulations. Interestingly, you don't have to specify maximum prospective liability. A financing statement will secure the original advance and any further advances automatically. So tacking's gone. The notion of tacking's gone, and I, for one, will not mourn its passing. So there'll be different rules. You can also perfect your security interest by possession or control, and there are different rules dealing with different types of personal property about how you take possession and how you assume control of negotiable documents of title or uncertificated shares or money in a bank account and so on. We haven't got time to go into them, but there are specific rules dealing with a myriad of situations whereby you can get perfection through possession or control. And then there's temporary perfection, and this is one of the hardest concepts to grasp. There are about 11 situations in which a security interest will be temporarily perfected, even if it hasn't been lodged for registration, and even if possession or control has not been taken. Sure, they've got some greater rights, they're offered some carrots, but there are stricter duties applying to both them and their receivers. Is there more certainty under the regime? Well, there's more efficiency in the sense that there's one national register covering most forms of personal property and most types of security interests. But have a look at the priority rules. They are a nightmare. They're very complicated, extremely complicated. And just at the risk of being a bit controversial here, is this using a sledgehammer to crack a nut? Are the legal problems great, or are the commercial problems great? Someone's got a commercial agenda here, and the government is saying we're going to lower barriers to entry, we're going to provide more competition for secured finance for business. And they believe that this is the way to do it. But I don't think it's driving a legal agenda so much, I think it's driving a commercial agenda. So it remains to be seen whether these cost savings will be achieved. Progress to date, well, as you know, the Senate Standing Committee reported in April this year. It had 11 recommendations. One of the mooted factors was whether the commercially reasonable test should be abolished. They proposed to retain it. There was a dissenting view that it should be abandoned, but they proposed to retain that. It was recommended that the transition to the new regime be delayed for a year to May 2011. The government has not accepted that recommendation yet. I'm not saying they won't, but they haven't yet. There were privacy concerns about addresses of various parties. They're going to be addressed in the Act. There's a privacy impact statement and a review period covered in the new recommendations. There's some suggestions about improving the drafting style. But basically, the Senate Standing Committee report is a fairly limp report with great respect. I don't think it does justice to the level of expertise shown in the submissions to the Senate Standing Committee. The major law firms put a lot of work into the submissions and made very cogent criticisms, but constructive criticisms, of the existing drafts. And I don't think, with respect, that those criticisms have been adequately addressed. And they might not be addressed in any new version that goes through the legislative process. But at least at present, we think the regime is time to start in May 2010. The regulations will be passed next year. I suspect some of the regime might be introduced. I can see no reason why the register cannot be set up and the migration process started. I can't see any reason